Welcome viewers. The litigation, Brunson v. Adams, claimed nearly 400 members of Congress violated their oaths of office by not investigating claims of voter fraud in the 2020 election and voting to certify Joe Biden's win. In this video we will break it all down for you. But before we continue, please take a minute of your precious time to hit the subscribe button below and turn on the notification bell to get the latest update from us. Rowland Brunson, the lead plaintiff in the suit, along with brothers Loy and Deeren, asked for those members of Congress, along with President Joe Biden and Vice President Kamala Harris, to be removed from office and barred from ever running again. Similarly, former Vice President Mike Pence would also be banned from holding another elective office. In an order published Monday, the Supreme Court said it would not hear the Utahns' case. On Friday, a small group of Brunson's supporters met outside the Supreme Court in hopes of encouraging justices to hear their arguments. The suit also ignored the order of presidential succession laid out in the Constitution by asking that Donald Trump be made eligible to return to the White House. According to Deeren Brunson, lawmakers' refusal to look into election fraud claims was akin to treason and an act of war against the United States. No credible evidence has been presented of widespread fraud during the 2020 presidential election or that it impacted the outcome. The Supreme Court announced on Monday that it will not take up a lawsuit against former Vice President Mike Pence, President Brain Dead Biden, Vice President Simpleton Kamala Harris, 291 House members, and 94 senators over the contested 2020 election. The lawsuit argues the 388 defendants violated their oaths of office by refusing to adequately investigate the 2020 election before accepting the electoral votes on January 6, 2021. This allegedly led to Biden and Harris being illegitimately inaugurated. The petition was denied, plaintiff Rowland Brunson posted Monday on his Facebook account. "We will now make our next move. A petition for reconsideration. Hang in there everyone. Hello my fabulous patriots and friends," petitioner Rowland Brunson also stated on Facebook. Okay. Here is the deal with tomorrow's decision. The Supreme Court's schedule of posting decisions is always the Monday following conference. So, we won't know anything until Monday. Now, don't think for a second that my brothers and I are not prepared for a denial. We've got plenty of chess pieces still at play, and we still have our queen. Through hard knocks we have learned how this political litigation game works, so keep up the prayers and your letters to the Supreme Court. You count. We love every one of you. Thank you for your wonderful support. The Brunson lawsuit is only one of a number of high-stakes legal battles expected to be fought in 2023. The Electoral Count Reform and Presidential Transition Improvement Act of 2022, also known as the ECRA, was buried deep in the $1.7 trillion omnibus spending package passed in December. The sweeping act places limitations on the ability of voters to dispute elections through representative bodies. The legislative reform deprives the vice president of the power to return slates of electors to contested states, as Trump demanded that former Vice President Mike Pence to do on January 6, 2021. The ECRA now states that the vice president has solely a ministerial role in presiding over the joint session of Congress when lawmakers certify electoral college results. Furthermore, Congress is raising the threshold to return a slates of electors to a state to 1/5 of the House and 1/5 of the Senate. However, constitutional scholar named Rob Natelson, who taught constitutional law for 25 years and whose scholarly research has been cited numerous times in Supreme Court cases, believes the ECRA constitutes federal overreach. He argues that some provisions of the ECRA are likely to be struck down by the Supreme Court. The fate of the ECRA may hinge on a forthcoming decision in the Supreme Court case Moore v. Harper, which is expected to be rendered in June. The court is now deliberating on the North Carolina General Assembly's claim that state lawmakers have sole authority independent of state officials and state courts to regulate federal elections, as stipulated under the Election Clause within the U.S. Constitution. Another court case on elections was decided on January 6. 3 federal judges ruled on Friday that South Carolina had racially gerrymandered its 1st congressional district and thus must redraw the map. Please, what is your take on this? And remember to subscribe as well. Thanks for